The complexity of the United Kingdom in the illegal rendition and detention of British citizen Mazi Nnamdi Kanu in Nigeria. This message is from IPOB. But beyond this IPOB's report, there is a trending message online now that UK about to lose relevance, in the sense that they are the culprit in the abduction of Mazi Nnamdi Kanu. Don't forget one of the videos I dropped yesterday. United Nations have got involved. Yes, they will say UK is the United Nations. My brother, you can never bamboozle everybody. Yes, you might have the veto power, but you can never bamboozle everybody. The same way Trump is doing in US. Trump will have the veto power. But don't forget, before he do anything, the House, the congressmen and women must, I repeat, their consent must be taken. So, as it stands now, UK is going to lose relevance. They have joined them in the league with Nigeria and also that of what do they call him? That of France and that of Kenya, who orchestrated this abduction and detention of Mazi Nnamdi Kanu, and that of Simon Ekpa as well. So Finland, Kenya, Nigeria, France, and UK have joined in one league games now as I am talking to you. This is verified information. You can as well log on to your www.x.com. The message is trending there. Anything Biafrans cannot do, let me put it that way, does not exist. Not that they are using this phrase to put where God is supposed to be on Biafra. Why do I mean why do I use that language? So Biafra is God and God is Biafra. Let us know this fact. The earlier you know this fact, the better for each and every one of them who is playing or who is trying to play with the emotions of Biafrans. Biafrans is God and God is the Biafrans. So when you try to when you try to jungle with somebody God is blessing, with somebody God is protecting, automatically you are digging your own grave. So all of them who have hands in one way or the other in what the Biafrans have been passing through all these years, my brother, their payment now is beginning to manifest. So just thank yourself and thank your God that you are a Biafran, that the world is speaking on your behalf. Anyway, let us go straight to the reason why we're here this morning. Nigerian army, look at what is happening in Imo State. We have governor in Imo State. The Nigerian army personnel, they are now burning our houses and looting our properties in Imo State. Burning houses and looting properties in Imo State. Chai. Anyway, that is a story after this main news. But if you get this message, please kindly drop your opinion at the comment section of this video. Like, share, comment, and make sure you keep subscribing. The indigenous people of Biafra, IPOB, decries the continued silence and apparent complicity of the United Kingdom in the face of Nigeria's gross and well-documented violations of international laws, domestic laws, and judicial precedent against Mazi Nnamdi Kanu, a British citizen and freedom advocate. Mazi Nnamdi Kanu was abducted in Kenya in June of 2021 in a state-sponsored criminal act of extraordinary rendition and forcibly returned to the Nigeria without any extradition proceedings, a flagrant breach of Section 15 of the Nigeria's Extradition Act, Article 12 of Subsection 4 of the African Charter on Human and People's Rights, and Articles 9 and 14 of the ICCPR, to which both Nigeria and the UK are state parties. What makes the UK silence especially appalling is that this is not an abstract diplomatic disagreement, but a matter in which the United Nations Working Group on Arbitrary Detention, opinion number 25/2022, unequivocally declared Mazi Nnamdi Kanu's detention illegal and ordered his immediate and all-conditional release with compensation. The Kenya High Court ruled that his abduction on Kenyan soil was unconstitutional and awarded damages for Kanu's complicity. The Nigerian Court of Appeal, October of 2022, held that Nnamdi Kanu's extraordinary rendition constituted a fundamental violation of Nigerian law, effectively nullifying the proceedings against him. The Fulani High Court, sitting in Umuahia 2022, awarded him 500 million naira in damages for the same violations. 3 judicial forums in Nigeria, Kenya, and at the United Nations level have all concluded that Nnamdi Kanu's fundamental rights were trampled upon and also bamboozled. Yet, the UK government, under the pretense of consular ambiguity and dual nationality, has refused to act or even issue a formal condemnation. This is in stark contradiction to its own principled reaction in the Diko affair of 1984, where it condemned Nigeria's attempted rendition of Umaru Diko from the UK in the strongest diplomatic terms. Severe diplomatic ties and threatened legal action for violations of international law and British sovereignty. In Diko versus the State of 1987, 2, Part 56, in bracket 539, the Supreme Court of Nigeria, Karibi White, JSC, made a judicial pronouncement that remains timeless. The trial of an accused person who has been brought before the court in violation of international law and without compliance with extradition procedures is nullity. Jurisdictions cannot be conferred upon the court by illegality. It is deeply ironic, if not disgraceful, that while Nigeria is abandoning its own Supreme Court precedent, the UK has chosen silence, thus betraying the very principles it once stood for. To add further insult to injury, the alleged offences for which Mazi Nnamdi Kanu is being persecuted, primarily political broadcast, were not committed in Nigeria. The applicable Nigerian law, Section 76 of the Terrorism Prevention and Prohibition Act of 2022, provides that Nigeria courts can only assume jurisdiction where the alleged act is also a crime in the place it was committed. The well-established principle of double criminality. There is no evidence, no allegation that the UK, where these broadcasts were allegedly made, has found them criminal under UK law. Therefore, by Nigerian law, no court in Nigeria has jurisdiction from the onset to put Mazi Nnamdi Kanu on trial. These are the Biafran demands. In view of the above, we call on the United Kingdom government to publicly condemn the extraordinary rendition and continuing detention of our leader, Mazi Nnamdi Kanu, invoke diplomatic and legal mechanisms to demand his immediate and unconditional release, clarify its position to the British Parliament and public on how it justifies inaction where a British citizen is legally abducted, tortured, and indefinitely detained in breach of international laws. British silence in this case is not neutrality, it is complicity. The UK must choose between its stated commitment to human rights and the rule of law. It is political convenience in shedding a rogue state. It cannot do both. History will not forget where Britain stood in this defining moment of one of their citizens, Mazi Nnamdi Kanu. Moving forward, Nigeria Army have been accused of burning and looting property in a community in Imo State. A civil rights organization, the Rule of Law and Accountability Advocacy Center, has charged that personnel of the Nigerian Army engaged in looting and setting fire to properties in Omalumaku, located in the Ehimembanu local government area of Imo State. RULAC report that the security agencies believed to be members of the Nigerian Army removed valuables such as food items, household goods, mobile phones, and personal belongings from the ancestral home and private residence of Mr. Anayo Vigilus Njoku, a law-abiding Nigerian citizen and technician residing in Lagos. The mode of operation of the security personnel involved in this incident is a clear breach of human rights and the rule of law, said Okechukwu Nwanguma, RULAC's executive director. We urge the Chief of Defense Staff to take immediate action to investigate this incident and ensure accountability. In a petition to the Chief of Defense Staff, General Christopher Musa, dated July 26, which was made available to Sahara reporters on Wednesday, RULAC urged him to investigate the incident and ensure proper accountability. The organization has also demanded that the defense headquarters clearly communicate operational protocols to all deployed units, reaffirming that arson, looting, and reprisals are unlawful. We emphasize that even in the face of insecurity, the Constitution of the Federal Republic of Nigeria and the Nigeria's international obligations prohibit extrajudicial punishments, collective retributions, and the destruction of civilian property, Nwanguma said. Given details of conduct atrocities, the petition stated, "We have received a detailed and anguished petition from Mr. Anayo Vigilus Njoku, a law-abiding Nigerian citizen and technician based in Lagos, whose ancestral home and personal residence were looted and burned in the said incident. According to Mr. Njoku, both homes, his late father's and his newly completed retirement house, were completely destroyed by Nigerian military. Valuables including food items, household goods, mobile phones, and personal belongings were carted away. His relatives who attempted to extinguish the fire were allegedly threatened at gunpoint by soldiers on the scene. While we recognize the complex and deteriorating security situation in Omalumaku and surrounding areas, we must underline that state-sanctioned reprisals, collective punishment, and property destruction cannot substitute for lawful and intelligence-driven law enforcement. RULAC is aware that Omalumaku and the other parts of Imo State have been under siege from criminal elements, including violent gangs and suspected spiritualist militants from within and neighboring communities. Reports of robberies, kidnappings, disappearances, and attacks on security personnel have sown fear among residents. These have in turn triggered military and police reprisals, often carried out without proper investigations and leading to human rights violations against innocent civilians. Residents are understandably afraid to provide information or testify publicly, making independent verifications of such incidents difficult, and increasingly the risk of unlawful profiling, extrajudicial action, and destruction of civilian livelihoods. It added, regardless of the challenges, it is the constitutional and moral responsibility of security forces to act with restraint, professionalism, and strict adherence to human rights and the rule of law. We emphasize that even in the face of insecurity, the Constitution of the Federal Republic of Nigeria, Section 34, 37, and 43, including 44, and the Nigeria's international obligations prohibit extrajudicial punishment, collective retribution, and destruction of civilian properties. The incident has sparked outrage, with many calling for the Nigerian Army to respect human rights and the rule of law in their operations in the whole of Southeast. RULAC's demands include immediate investigation, disciplinary action against personnel found to have acted outside their mandate, and compensation to Mr. Njoku and others whose homes or property were destroyed. The use of excessive force, reprisals, and indiscriminate targeting of civilians in response to criminal activities by unknown or unaffiliated individuals is a clear breach of human rights human rights, Wanguma said, security must not come at the cost of justice, and enforcement must not descend into vengeance. The Chief of Defense Staff has been urged to lead by example and demonstrate that the Nigerian Armed Forces remain bound by constitutional limits and committed to upholding the rule of law, even in the face of daunting challenges. The organization, which copied the petition to United Nations Office for Human Rights in Nigeria and other relevant agencies, including the Office of the National Security Advisor, regretted that it has become a trending partner of the Nigerian security, especially the military, of willfully destruction and looting of innocent people's properties when engaging in security operations in the whole of the Southeast. So, my good people, with a few points of mine, I hope I'm able to convince you, but not to confuse you, that UK is going down. Rakiji, Nasimba, is either they allow the Biafrans to go, or they will completely remain in the past, because UK is going to become past. As for Biafrans and Biafra, we are marching forward. We have gotten to the Rubicon, and there is no going back. Whether the devil like it or not, Biafra must stand, and that is the way it is. So have a nice day, my good people of Biafra, and the ones who believed in their daily news from this daily platform. I say, may Almighty Chukwu Kiagama bless you, prosper you, and meet you at every point of your need. If you get this message, you know what to do. I have done my part. Please do your part by circulating this message. We want this message to get to Kaistama and the so-called Kemi Badenoch. UK is going down. It's either they allow the Biafrans go, or they will pay the ultimate price. And you know what it is. So have a nice day. May the good Lord continue to see us through, prosper us, and meet us at every point of our needs. Kachineke Mezioku.